Okay, so right now we're going to be talking about separation of powers. So just a quick recap of where we've come from. We talked about the fact that the experience with the crown was viewed as negative, and that gave the colonists, and then of course when they created the nation, that gave them a sense, a distrust of a strong centralized government. So the first governing document was the Articles of Confederation. That was in effect between 1776, the Declaration of Independence, and 1788, that 12-year period before the Constitution was ratified. The Articles created a very weak central government, and by the time 1788 rolled around, they realized that was not working, and they needed to create a central government that had more powers so that it could govern and do the things they wanted it to do, like putting down Shays' Rebellion. But they also realized that they wanted to control those powers and to set up structures that would do that. So the three structures that they set up, built into the Constitution to control the powers of the central government, were number one, separation of powers. That was the men are not angels. Number two, federalism. That's the 10th Amendment that we're going to be talking about in future lectures. And finally, the Bill of Rights, which explicitly created certain rights that were retained by the people in the states and that the federal government could not touch. Okay, so let's talk about separation of powers. As we know, the three branches, the legislative, the judicial, and the executive branch, doesn't matter if you put which you put where on the triangle, it's just the idea that all three are there. When we talk about checks and balances, we split you guys into three groups. Some were looking at Article 1, some looking at Article 2, and some looking at Article 3. So, of course, Article 1 created the legislative branch. That was the only branch they had experience with under the Articles. So that was the first branch that they dealt with when they created the Constitution. Article 2, the executive, of course, and Article 3, the judiciary. All right, so the group that looked in the legislative branch saw a number of interesting checks and balances. Same with the executive branch. So let's talk about them. One check that the legislative branch has on the executive branch. Well, let's do it this way first. Let's check the executive branch has on the legislative branch is the veto, which is set up in Article 1, Section 7, Clause 2. So if Congress passes a law and the executive doesn't like it, he or she can veto that. Of course, a power that the legislature then has over the executive is the override, also Article 1, Section 7, Clause 2, which says that if the president vetoes a bill, it then goes back to Congress, and if Congress can pass it, rather than with just a simple majority in each house, if Congress can pass it with a 2/3 supermajority in each house, then the bill becomes a law absent the president's signature. Some other checks and balances that we talked about is that the executive and the legislature over the judiciary. So in Article 2, Section 2, Clause 2, the Constitution states that the president gets to nominate nominees to be considered to be Supreme Court justices. And the legislative branch, then specifically the Senate, gets to confirm or kind of not confirm those nominees. So you don't get onto the court unless the president chooses you. So choosing court members, that's Article 2, Section 2, Clause 2. And then the Senate has a role in confirming those nominees, confirmation. Now, a number of other things came up when you guys were looking at the various articles. For example, the power to declare war, Article 1, Section 8, Clause 11, is given to Congress, but the power as commander-in-chief, Article 2, Section 2, Clause 1, is given to the president. So the splitting of those two pieces of power over the military and war was seen as a way to keep those two branches working together and to split power over that important issue of war. All right, so we talked about some other checks and balances, but these are some examples. And when the group that looked at Article 3 was looking through Article 3, they realized that there were no explicit checks built into the Constitution that the judiciary had over the legislative and the executive branches. That's where we jumped into the case of Marbury versus Madison. All right, let's talk about Marbury. In Marbury, what happened, we talked about the Revolution of 1800, which was the first time that power was handed as a result from one party to another as a result of a hostile election. So in 1788, when Washington was elected, he was really pretty much the only candidate. He was elected again in 1792. 1796, he passed the mantle to John Adams, who was also a Federalist like Washington was. And Washington was happy to see John Adams become president. Now, in the election of 1800, Adams, the Federalist, was running against Jefferson, the Democratic Republican, and they were, of course, the heirs to the ideas of the Anti-Federalists. And Jefferson won. So that was when I asked you in class to imagine the moment when John Adams had to hand over the keys to the White House to this man who he genuinely believed was going to potentially drive the country to ruin. Politically, he did not like him. He did not like his ideas. He didn't like him personally. So a very consequential moment in the history of democracy. Because, of course, the president is commander-in-chief. Maybe Adams could have said, no, I'm not going to turn over the keys to the White House. But we all know he did turn over the keys to the White House to Jefferson, handing power over based on nothing but the silently expressed will of the people, going out and voting in schoolhouses and churches across the country. Silently, they took down John Adams as the president, the Federalist president, and gave power to Jefferson. Okay, so Adams did hand over the keys, but he did something else as well. Before he left office, Adams appointed a number of Federalist judges who were going to take new posts that had been created in the judiciary. Now, we've talked about the fact that the courts, the judiciary, they serve what Article 3, Section 1 calls they serve during good behavior, which means that they serve for lifetime tenure until they are either removed for bad behavior, very uncommon, or they retire, or they die. So the bottom line is that Adams was hoping that these Federalist judges would have an impact on the judiciary for a long, long time, long beyond, of course, Thomas Jefferson's tenure as president. So what happened is that Marbury, he was one of these so-called midnight judges. I'll draw a gavel to signify that he was a judge. Marbury sued Madison. And Marbury sued Madison because before Adams left office, they got all the paperwork done, they created the positions, but the last piece needed to be done, which is that they needed their paperwork stamped by the executive branch. And that did not happen for a number of these judges before Adams left office. So at that point, Marbury was suing Madison. He was a representative of the Jefferson administration. Remember that new Democratic Republican administration. So Madison was a representative of the Jefferson administration, and he asked the court to force the Jefferson administration to force them to stamp their paperwork. Okay, we'll continue in the next tape.